the Second Circuit here, I mean, I feel unfortunate position they're in because they're trying to interpret Lora, right? So you talk about 31 years, they're interpreting Lora, and they say after Lora, where we said that Congress specifically chose to locate 924J outside 924C. They're separated by several unrelated subsections. We said this reinforces the conclusion the Second Circuit said that Congress intended to create different crimes subject to different penalty schemes. 924C focusing on the firearm, 924J focusing on the death caused by the use of the firearm. And again, that was discussed at oral argument in Lora. In fact, the government cautioned us against not answering this question in the way that the Second Circuit, ended up saying, and now we're back. So what, Lora's got to be part of your analysis here. How do you explain Lora?
Lora favors us, Your Honor.
Why?
Because it's odd that the Second Circuit said, we're kind of compelled now by Lora to reach this conclusion.
You think that's odd? Okay.
I think it's odd, and this is why, Your Honor.
I don't think it's that odd, but anyway.
The reason I think it's odd, Your Honor, is because this court said that our position in this case aligns with Your Honor's ruling in Lora, right? This court said, J does not incorporate C's penalties. Congress wrote J to punish a killing. The penalties it set out were sufficient in themselves. It didn't want to replicate. It didn't want to pile on. And although the precise question here was reserved, Your Honor, whether these two crimes are the same for double jeopardy purposes, there is no dispute among the parties that they are the same. So the only question is there a clear indication? Is there special authorization, to use the phrase in Wayland, from Congress to double punish the one fatal shooting here? And there simply isn't. Amicus has not pointed to anything saying so.
Well, I think they've pointed to in 1994 when Congress comes in with J, they already know that 924C D12, C1 D2 already says that any new punishment will be consecutive. If Congress knows that in 94, they know they don't have to put something in to make clear that it's double punished. It's already by definition going to be double punished given what that already says, correct?
C1, no, Your Honor, respectfully. C1D2, as Justice Sotomayor was describing, is an instruction on how a sentence should run if imposed under C. That's the question here. If we assume—
You said the question was an intent by Congress to double punish.
That's correct. So did Congress want a sentence to be imposed under C along with one under J for one crime? That's the question, to which C1D2 says nothing. And finally, Your Honor, if we presuppose C1D2 applies here, we presuppose the answer to the question.
The Second Circuit also noted that the district judge said he was going to do a 50-year sentence regardless here. That the Second Circuit can deal with that, I suppose, even if you prevail.
Yes, and just to be clear, Lora came up while we were litigating Barrett in the court below, so we filed supplemental briefing based on Lora, and the district judge rejected our argument given circuit law at the time, but he specifically told Mr. Barrett, if I'm wrong, you'll be back here for a new sentence.
Right, and that's why the Second Circuit didn't find it harmless.
Right. So we don't know what the judge will do on remand. We don't.
Yeah, thank you.